proposed order. The effective, which would be revoked to serve 90 days with credit for his time since he was arrested on these violations in March. And then reinstated after the service of the 90 days. He may also apply for rehab if he like to do so.
Mr. Brownley, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full name for the record.
Brownley.
Brownley, you've heard your lawyer go over what the agreement is. Do you understand that you're here on a violation of probation, that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation?
Yes, Your Honor.
You understand that if we had that hearing, you'd have the right to have a lawyer and have one appointed if necessary, which we've done with a public defender. You understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to that hearing or that appeal. All I'm going to do is approve what your lawyer will tell me to say. And that's going to require you to serve 90 days with credit for time served and then reinstate you to probation with the condition that if you want to apply for a rehabilitation program, then that will be authorized as well. You understand everything I've explained to you?
Yes.
Do you want to plead guilty according to this agreement?
Yes, Your
And upon your plea of guilty, I find you guilty, or that you be revoked the served sentence, but to serve, 90 days with credit for time served, and thereafter you'll be reinstated to probation with the condition that if you seek to apply to, I'm assuming that application to a rehab would be while he's serving that 90 days. So then you'll be authorized to have a furlough if you're accepted into an inpatient treatment. So, okay. All right, thank you.
Yes, Your Honor, only request is a speedy trial, please. If Your Honor would sit.
Speedy trial
Set for trial today?
tomorrow.
Not yet. We're just setting our status today.
Maybe the 13th, so we don't run into holiday.
Well, we have the 12th and the 13th. You want to put it on the 12th or the 13th?
I'd like to do the 13th, just in case Paul Davidson goes. This will be a one-day trial. It will not go 2 days.
All right, Mr. Seabury is set for trial on the 13th of August.
A little slow coming up.
That's fine.
I believe Your Honor will simply need to, if Your Honor will allow, reset this for Judge Wallace's the court date coming up. I've been informed they're anticipating an amended violation of probation warrant that we might get served on later.
Will Judge Wallace's next day is May the 11th. We'll reset it for that day.
May 11th. Thank you.
Asking for one more status date for this case. I think we'll settle it. There's just a few details that we're working out between our client and victims. And I'm pretty confident that this was done.
That would, if it's on my docket, it would be that August the 10th date, August 10th.
Thank you, Judge. Thank you.
That always let your lawyer come up. So. Sorry, Mr. Clemens, this is Jennifer Holloman.
Yes, Judge, we have a settlement ready on this one. Pass this up, please.
All right, thank you.
Pleading guilty to the charge amended to attempted forgery, received a sentence of 11 months, 29 days suspended, and a $50 fine.
Holloman, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your full name for the record.
Jennifer.
Ms. Holloman, you are here today on a charge of forgery. It's been indicated you're going to plead to an amended charge of attempted forgery. But have you seen or been shown a copy of the charges against you? Talk them over with with your lawyer and Mr. Clemens, and you discuss the range of punishment you're facing as well as any possible defenses you might have.
Yes.
You feel like you fully understand what you're charged. You understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court. You understand that by pleading no contest or no contendory, all that means is you're not going to admit you did anything. But you're not going to contest the state's evidence when they tell me what their evidence would be. And that evidence will be used by me to find you guilty according to this agreement. You understand all that? All right. You understand that you would have, if you went to a trial, you would have the right to have a lawyer and have one appointed, as I've done with the public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time as ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that trial, you and Mr. Clemens could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by using a subpoena. You understand that if at trial you'd be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by pleading no contest, you're waiving your right to that trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes.
You understand that that is going to result in a misdemeanor conviction, and that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes.
You want to plead no contest according to this agreement and waive your right to a trial and to an appeal. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty. And listen, as the state tells me what their evidence will be if this case is going to trial.
Your Honor, the state would put on proof that if this case had gone to trial on May 14th of 2025 and July 23rd of 2025, she was on probation with Ms. Donnelly here. She had volunteered to do some community service, so she had a community service timesheet that she was supposed to present to the court. She did a couple of days of that, and then she signed the supervisor's name to the rest of it. The state has talked to her attorney, and we are going to give Ms. Holloman one more chance. Get out there and do probation. She'll either get it or she won't.
All right. Ms. Holloman, you understand that's what the state's evidence would be if this case went to trial.
Yes.
You still wish to plead no contest according to this agreement. Are you satisfied with your attorney's services?
Yes.
Feel like Mr. Clemens has done a good job of representing you confidently.
Yes.
I mean, you know of any reason she should not enter this plea?
No, Your Honor.
Ms. Holloman, this is the last chance you're going to have to avoid going to jail, so make sure you make the best of it. On your plea of no contest to count to the attempted charge of, to the amended charge of attempted forgery, a Class A misdemeanor, I find you guilty. Sentence you to 11 months and 29 days in county jail, but that would be suspended to supervised probation in order to pay a $50 fine and court costs. Good luck to you.
Stand in for him today. He was asking to pass his motion, and the state is not going to disagree with that. I believe we settled this case. But I don't know what this is.
So
I think he'd emailed Ms. McKinney about resetting it, but let me call them.
Mr. Finley,
Yes.
he said that he had, court in
Yeah,
Clarksville
in Clarksville, so.
and that, he needed another status date, requesting waiver of appearance for himself and his client. And I'll let him know that. And to discuss that with you, the motion needed to be made.
well,
They needed to be in agreement, all that stuff.
the fact is that it was. Let's see.
I think he can be here after lunch, he said, Your Honor, if his staff is coming.
I have a problem with he coming in on Zoom if that's what he needs to do. I'm just trying to figure out what we're doing with his client. So the motions were set for today, but he's wanting to pass the motion.
And I'm fine with that, Your Honor. I think we'll.
Why don't we just pass it to that August the 10th day and save everybody the trouble? No, we'll pass, Mr. Miller, your case will be passed for the hearing on motions and final status day, which means y'all don't work something out on that day, then I'll set you a trial date. Once I set you a trial date, you'll be required to go to trial and plead to the indictment and go to sentencing. Okay, stay in touch with your lawyer. August the 10th.
Yeah, I'm gonna ask a question.
Yes,
Me and my family drove down here, it would take 20 hours to get here.
I'm sorry.
It's 20 hours from me to get here, I live in Minnesota. Just wondering if there's any way, if it's just another hearing, and most of it to be heard on Zoom. Obviously for the trial, I would have to be here. It's another thing.
Well, let your lawyer deal with that. He can file the appropriate motion to allow it to be considered by the court. we don't normally, since you're here in person, allow an oral motion for you in the future to not appear, but I'll consider it if Mr. Finley files the appropriate motion. We'll look at, maybe that's, for just the status, it would not be possible for a trial.
You'll know before your next
Yeah.
court date.
Yeah, appreciate it. Thank you.
All right. 25 CR 68, State versus Robert Paul Norman. Clemens.
Yes, Your Honor. Your Honor, I've lost contact with Mr. Moore. If he's not here today, that I can tell.
Robert Paul Norman.
I gotta have to tell the court that.
Well, since he's not here on the day for the status hearing, I'm gonna have to revoke his bond. If you find that there was some legitimate excuse for him not being here, such as hospitalization or some other issue, then you just get in touch with me and we can set it aside. But right now, I'm gonna issue, you know what his bond is?
I will. Thank you.
Looks like it's given a war bond.
Has an OR bond. I will revoke that OR bond, issue a capias for his arrest, $5,000 for the bond, cash or commercial only.